Hello, this is Product Attorney Jason Oakes with your Wyoming Health Watch. Today I wanted to talk about some of the emerging climate change cases that are fast working their way through the court systems. And I think this is of very important topic, especially due to the fact that I'm number one, from Wyoming, number two, that I do a Wyoming Health Watch. But this shouldn't just be limited to Wyoming. Anybody who lives in a state that relies on fossil fuels should be very interested in this podcast and in what's fast going to become what I think is an enormous topic of publicity and conversation in the near future. And that is the litigations that are working its way through the federal system and the state system right now that are seeking to hold responsible major fossil fuel companies like BP and Chevron and others for their part in the climate change that we are seeing throughout the United States and even the world. And that's aside from the fact whether you believe in it or not. These cases are going to go before a jury. They're going to be civil cases, which means this is not a beyond a reasonable doubt standard that is going to have to be proven, but rather a preponderance of the evidence, which means you provide all the evidence, you put it on a scale. The plaintiff puts his evidence on the scale, and I'm speaking figuratively, and the defense puts all his evidence on the scale, and which one tips ever so slightly wins. We describe it in plaintiff's terms as more likely than not. It has nothing to do with doubt. You can have all the doubt that you want. The question is not about whether or not there's doubt in your mind. The question is, after reviewing all the evidence, is it more true than untrue? Is it more likely than unlikely? And if the answer is yes, you are compelled as a juror to find in favor of the plaintiff. So here, there are various groups and various plaintiffs who are asserting a number of claims. Most predominantly is the public nuisance claim. And this is important because public nuisance has taken on a whole new road recently, primarily with respect to the opioid crisis, which my firm has been involved with for 2 years now. We represent counties and cities across 4 Rocky Mountain states. And when that litigation started, the argument of public nuisance was somewhat novel. The argument being that a company in the opioid situation can cause a scenario that causes a public nuisance, and therefore a community such as a county or city can seek to recover damages that they have lost as a result of dealing with the nuisance. That's the basic argument for public nuisance in the opioid litigation, and that very argument went before an Oklahoma judge, and just a couple months ago, asserting that Johnson & Johnson was responsible in part for the epidemic of opioids there in Oklahoma, and the theory that was pushed forward by the attorneys in Oklahoma was the public nuisance theory. The judge found Johnson & Johnson responsible on a preponderance of evidence standard in order that they pay $572 million to the state of Oklahoma. And that was with a number of defendants settling their responsibilities before they exposed their risk before the judge. So we now have an order that holds a company responsible for public nuisance out of the Oklahoma opioid litigation. And that order is entitled to what we call the full faith and credit clause. And the full faith and credit clause means every state and every federal court should respect any orders from other jurisdictions. Now, they don't always have to follow them, but there's almost an immediate acceptance that order is accurate. And so what lawyers do on both sides of the table, whether you're plaintiff or defense, if you win, you take that order and you parade it everywhere you go. And obviously that's what the plaintiffs are doing as a result of the opioid litigation. And we've seen this transform itself into public nuisance arguments by school districts now that are filing cases against Juul for the same argument. Public nuisance that's been created in school districts as a result of the vaping epidemic and crisis that's going on throughout our high schools and even our middle schools. And the school systems are arguing that Juul should be responsible for compensating the school districts for the lost productivity and all the work that they've had to do to try to clamp down on this problem. So bringing it back to the climate change crisis, the same arguments are going to be pushed forward. The same arguments, at least the same legal theories, have proven to be successful in court, public nuisance, and it's going to be a very, very interesting to watch these climate change cases, many of which are stacked behind one another, seeking their day in court to see how they turn out by these private lawsuits. I think one thing to think about is there is a clear polarization in the political world right now about climate change. And from our perspective, from my perspective, it doesn't matter what the political world thinks right now, because the judicial world, the legal world, is going to have to contend with this matter one way or another with these cases moving forward. So this week, in fact, yesterday, an enormous lawsuit began trial in New York. The Attorney General of New York is suing Exxon for, as they allege, Exxon had lied to investors about their role in climate change. And as a result, investors have been squandered money, according to the New York Attorney General. In his opening statements yesterday, he told the judge, frankly, that he was going to be asking for $1.6 billion. That's billion with a B. So an enormous sum of money. Also yesterday, there were 3 lawsuits that were all filed in state court alleging various forms of public nuisance against major fossil fuel companies like BP and Chevron and many others that you've heard of. Chevron and BP and the defendants filed an emergency motion to the U.S. Supreme Court, asking the U.S. Supreme Court to halt these trials and halt these cases from moving forward in state court, to which the U.S. Supreme Court yesterday said no, they were not going to halt them. So those cases will be starting to work themselves through the system here very quickly, and there are a whole host that line up after them. It's going to be a very interesting thing to watch. Regardless of politics, the day of reckoning is going to happen one way or another, whether it's for the plaintiffs or the defendants. Time will tell. But nonetheless, from a state like Wyoming and others of you who are from states that depend heavily on fossil fuels, we need to take a watch of this. We need to see how these cases develop, and we really need to see how the verdicts turn out, because if the verdicts turn out really big and really high, there's going to be a drastic change that's going to have to be dealt with in states like mine in Wyoming. We'll keep you updated on this. We are very interested in this. It's going to be something that's going to take precedence, I believe, over the next decade through many of our court systems. We will keep you updated. If you're interested in learning more, check out our website at wyominghealthwatch.com. If you also want to listen to this podcast again, you can also go to wyominghealthwatch.com and access this podcast and other podcasts and information concerning these lawsuits. Again, thank you. I'm Jason Oakes, and this is your Wyoming Health Watch.